No, he is perhaps calling for the Janax.
Or with regard to item number 5, 6, 7. With regard to item number 5, 6, 7, and 9, sir, we find out written arguments. Can we talk about
5, 6,
7 and 9?
7, and 9.
We find out written argument. Can we talk about
Okay.
Supplementarily stated 30th January 2021, which was fixed for hearing, but the matter was left. May I please note moving the matter on 8th February.
Okay.
Roship, I beg to mention item number 1 for adjournment.
1 is 2017 matter.
Lordship has heard it once. It was parted. But then his sister-in-law expired.
Oh,
Mr.
acha,
Siddharth
okay.
Buragohai.
Okay. Okay.
May it be fixed on after 12?
Uh, your name?
Roship John Khamte. John Khamte.
Just write it down. Write it down. As so advocate on behalf of Mr. S. Borgohain, Commander and Council on record for the appellant has submitted that the Learned Council holding the brief is in bereavement. Stop. Accordingly, matters stands adjourned today as Jahan Raner APP is present. List on.
Well,
15
15th of February.
February 2024.
Item 18, 19 part আছে কেস রেকর্ড তো স্যার আহি আছে হিয়ারিং টু স্টার্ট করবে কেস রেকর্ড তো আহি আছে 18 with 19 দিন পার্ট আছে এই কেস রেকর্ড তো স্টার্ট করবে না বেলে গাই
এইটো কন্টিনিউ কৰিম ৰেকৰ্ডটো আহি থাকক
Item 18 with 19 part hard.
Yes.
Brief is a matter. In prosecution case, my comment is concerned. PW 5, 6, and 7 are with the vital witnesses to the prosecution. Whereas PW 5 is concerned, Lordship, it has categorically stated that it has saw both the accused go.
Please repeat again. I did not catch you.
5, 6, and 7 will be the relevant witnesses, Lordship. And PW 5 happens to be the independent witness. And it is remained undisputed that he saw accused Numal Gogoi and accused Deepak Gogoi, along with the deceased girl, at a relevant point of time. And that is remain undisputed, Lordship. Thereafter, Lordship, he has stated that the accused Deepak Gogoi got one girl, that is deceased, and they have went away in the site of the function after she got a call from Deepak Gogoi. And after some time, they again returned back and again accused Numal Gogoi, Deepak Gogoi and the victim. Deceased went away from the place of occurrence.
That is PW5.
PW5. That is remain undisputed. Statement confirmed, firm and consistent. Here, the prosecution case is entirely based on not on the eyewitness, but on circumstantial evidences. And the incriminating circumstantial evidences are as follows. On 23/03/2012, PW5, 6 and 7.
It will be
লোগোতে আছে
Right, please come to page 39 of the paper book.
Lordship.
In page 39, the question number 5 relates to PW5. The circumstances that he had seen the appellant going away with the girl victim for the second time is not the circumstances put before him.
That is not, there is no such suggestion.
So it dilutes the. Because you'll have to also address us on that point whether the whether this lack of those that circumstances before the accused in respect of respondent number 5, the PW5,
Lordship.
whether it would vitiate the finding of the trial court or it will not.
Lordship, may I point out one line, Lordship? Last fourth line, Lordship.
Fourth line, yes.
Yes, both of you. Question number 5, both of you accused Deepak and Numal and the deceased girl went on a bike to some distance from the place of function, but he does not know how the girl died. So that question probably put to him, Lordship. And he has merely denied the entire. That is your motion. Subject to correction to my understanding.
You just come to page 18. It is like, it will be clear. You see, third line, on the day of the incident, Ali Lingang function was going on at Kulajan. I saw accused Numal and accused Deepak along with the deceased girl at the site of function of the day of incident. The girl left the site of the function along with the accused doing a motorbike. I don't know as to how the girl died. So that statement in 313 is perhaps the first one. It doesn't refer to the second one. After returning, they went again. That is not the circumstances to which the accused was put to notice. So it is reproduction of the first part in the 313.
Lordship, the first part will be, Lordship, when we come to page 39. Question number 5. The fifth line, Lordship. At the place. Has the Lordship got it? At the place of the function, they saw both of you, along with the deceased girl. Perhaps this will be the first incident.
So they saw you.
They saw you. And
No, it's
both
okay.
the persons will saw you. Then again, Lordship, then again that question was put. Lordship, both of you and the deceased girl went on a bike to some distance from the place of function. Perhaps this will be the second occasion.
No, because you see, but he does not know how the girl died. No.
He doesn't know.
No, I understand. But you see, when a judicial magistrate is, the district judge is writing this question, I don't suppose he will write one line from first paragraph, second line from second paragraph, and then, third paragraph, and later line from the second paragraph. This is perhaps not envisaged. I used to do it when I used to cross-examine witnesses to confuse the witness. But a district judge who has experience in writing 313,
Lordship.
he will not do that amateur kind of questioning. When I was asking question, I had a intention to confuse him. So therefore, first question, then last question, then again second question, then for fourth question, I used to break the sequence in cross-examination. Because then the witness will not understand what is the link between the first question and the second question, or first question and the last question. He does not know the link, and therefore he can't, parrot a recitation of the events would not take place in the class. If a district judge does that, then you see the Supreme Court has very clearly said that short questions and those which spell out a sequence of events must be there in the 313 statement. Otherwise, this questioning is vitiated. He will not understand. He will say yes or no. So circumstance is first that you went, came back again. Second time they saw you again going, and then the girl vanished. That sequence is not perhaps there.
Lordship.
And because this question is verbatim reproduction of the first paragraph at page 18. So question in the examination in chief and question in the answer in the the answer in the examination in chief and answer in the cross examination, they can't be clubbed together.
They're putting in such a manner, Lordship, it means, Lordship, both the paragraphs have been clubbed together, it seems to be, in all the questions, Lordship.
Because you see in the cross-examination, he says that it is not a fact that I did not state before the police that I had seen the accused so-and-so going out with the girl.
Yes.
That means it's only a singular incident. Okay, whatever be that, we'll consider it.
The fact that the victim girl went with the accused group, that is well proved by prosecution witnesses PW 5, 6, and 7. And thereafter also, after the incident, after missing of the victim girl on the next day, the dead body was found lying on the body. And she was found and injuries were found on her back, that is in the vital part, that is on her brain portion. And that is also corroborated by the inquest report that injury marks were seen on the back and head of the victim. Equally, Lordship, postmortem report also says that the cause of death was due to neurogenic shock following injury to the vital organ, that is brain. And these things remain undisputed, Lordship. And thereafter, Lordship, PW 15. That is the IO. At page 32. Lordship. The reposition of PW 15, that is the IO. And the relevant page would be 33, Lordship. I have seized a broken mobile phone and a SIM card that belongs to the victim girl. Exhibit 4. And thereafter, Lordship, Exhibit 3, the silver list, I seized one LG mobile phone and one SIM card. I recorded the statement of the witnesses. I arrested the accused and produced him in the court. And in the investigation, the seized Airtel card belongs to Depot Group. And one motorcycle was also seized, that is Exhibit 5. And he has also spent the vaginal swab of the deceased for examination with the Director of Forensic Science, Guwahati for analysis.
See, this is electronic evidence. If you have spare time, you can open your SIM card from the mobile and see. It does not contain your name. Therefore, you see, somebody must give a better evidence saying that this SIM card belongs to A. The SIM card does not have a name. It contains numbers. So it is only the what do you call the vendor
Yes.
who has issued this SIM card. Only they will be able to say that this SIM card is registered in whose name. That becomes an evidence, not the SIM card. So SIM card belongs to A. Is a fact we can't take cognizance.
Because Lordship, thereafter.
No, it may be you see, something may come up from in my mobile. Today, if search is conducted, in my mobile, you'll find a SIM. But when it's evidence of the SIM is given, it's an electronic record. Somebody must say that whose it belongs to. Because SIM card does not have a name. That's why we are asking you that whether this itself creates an evidence. You see, the mobile use of mobile phone and SIM card is not questioned. But the second fact is that the girl and the boy, they have a meeting of mind. And with that intention, they left. Then there would be a call data which can be recorded and could have been retrieved to say that before the girl vanished, there was a call data which shows that they both were in continuous contact.
Yes. That triggers from the CDR call, Lordship.
Is it there?
Yes. Prior to the occurrence, they severely interacted between the victim and the accused person.
Where is the evidence?
No, that's not there. You see, the IO merely says, IO says Exhibit 7 is a sketch map. Then he refers to Exhibit 4 SIM card seizure list. Then material exhibit 1 is the seized mobile. Exhibit 2 is the socks. 3 is the SIM card. 5 is a seizure of motorcycle. Exhibit 8 is the charge sheet.
Exhibit 3, Lordship, 87,
Exhibit 3 is the seizure of mobile phone and SIM card.
from the possession of depot.
No, no. You see, that does not lead to investigation of crime.
But the case diary shows, Lordship, there is a frequent interactions between the deceased and the accused person depot.
No, no, case diary we can't look into. Well, it must be in form of an evidence.
It can be just a corroborative piece of evidence.
No, but where is that evidence? It's not marked as exhibit. You have seen the, you have read the case of this Jane diary. You see, you remember the case of Jane diary, no? Oh. Yes, V.C. Shukla. Yes. You see, you read that judgment, then you will understand. You see, today you are making submissions before the court, and I am presumably writing something. Correct. Now, let us say in a diary which was in that case, V.C. Shukla's case, a diary was seized by the CBI. In that diary, some financial transactions were noted. And all these ministers, MLAs, they were transferred money, and there was a writing maintained in that Jain Hawala diary that money is paid to so and so, so and so, so and so. But you see, that having been seized from that accused, still did not form could not lead to a conviction on the ground that, you see, it's my diary, I am writing something. So it's not within your control. You may not know it, that what I am writing. I may be spending money in auto rickshaw and writing that I have paid to the XYZ 100 rupees. But Mr. Mishra, I must admire your memory.
The next case I will be referring. Huh? Was whether the diary contain the loot sheets,
Yes,
where this will be book of account as mentioned in section
34 of the Evidence Act. Huh.
The other thing, in my diary, I can write anything. It has to be true.
Huh. That's right. It's not for others, but you read that, you will find the analysis, why it is necessary, how it is proved, how documents are proved, how entries can be proved. There is a judgment of this court saying that what can be books of accounts, loose sheets of diary, will not form a part of books of account within section 34. So it's not for this case, but you can just have a preparation made. It will give you a broad idea of the manner of proof. Huh?
Investigation.
Yes, yes,
So from that, there will be some date, etc.
yes.
My argument will be based again on the last seen theory. Both the accused persons and the victim girl was last seen together just prior to the occurrence of shooting. So the factum of having last seen the accused duo with the deceased victim at about 8:30 PM in the night hour of that intervening night stands duly proved by the testimonies of PW 5, 6, and 7. And Lordship, while he was examined under section 313 CRPC, Lordship, the onus lies on him as per section 106 of Evidence Act, that he has to give a plausible explanation as to how and when he parted the company of the deceased life. That means he owes an explanation to that regard. And if he it is well settled, that if he fails to offer reasonable explanation to discharge the burden of upon the accused, then itself provide an additional link to the circumstances proved against him.
Please repeat again, what provides additional link?
If he fails to give his
Oh,
plausible
acha,
explanation,
okay.
so how and when he parted the company of the victim. And it is well said, your lordship. It is aware of your lordship's knowledge that lasted theory would come into play when duration of time gap between the accused duo seen in the company of the deceased alive and the detection of the crime is small, that the possibility of another person being with the deceased should be completely ruled out. And there is nothing on record to show such possibilities that any third party has involved in the state crime.
No, apart from last seen theory,
Not
you are relying on what else is there against the appellant? What,
while he was examined under section 313 of CRPC, he has taken the plea of total denial, Lordship. That will also not do, Lordship. Mere denial will not do because he has to explain. The onus lies on him to prove the fact that he has to give some plausible explanation to that regard, at when and how he parted from the company of the deceased.
You see, exactly that is what we are trying to understand. You see, in 313, if that question at question number 5 is taken as the first part, then the second question was not brought to his notice, and therefore the second time that they went was not put to him, and therefore there is no question of his giving a volunteering a reply. He has a right to remain silent.
But
106 would attract, but when he's put that second question, that's for the second time again you left.
subject to correction, Lordship.
And then you see something must be there, more incriminating materials. Number one, this motorcycle should have been, it ought to have been, this person who had brought in the mobile, that motorcycle, he was not put a question, who gave it to you? So if the accuser has given him the motorcycle to keep it back, then he would have said that. So therefore, there must be some link. The spermatozoa was not sent, the medical examination report, there is a break in chain of custody.
Lordship,
The
to that
whose
regard,
spermatozoa it is, that's not proved.
To that regard, may I come to page 36 of the paper book, Lordship? That is deposition of PW 17.
But this last scene theory is something which I was just I tried to analyze. You see, perhaps that is the reason I don't mix up with people. I'm last seen in some place with somebody whom I don't even know. Maybe in a marriage, you see, you have 1,000 guests. Out of that, you may know 10 people, but 990 people you don't know. And there's a possibility that your position in standing would be photographed. You are taken photograph with some XYZ, who is otherwise you think is not to be mixed up with. But it's that is a situation not under your control. So therefore, last in theory, if it said that a crime was conducted, had occurred on 31st January. 31st January, 10 o'clock, he was seen in that marriage with these people. And then 10 o'clock and 11 o'clock, there is a crime. The question which comes to my mind is whether last in theory can apply to something which is unconnected with the actual crime merely because of a photograph which was taken somehow. And then say that this man was involved in a crime. At 10 o'clock, his photograph is with X, and therefore X is also a party to the crime. But there must be something to link it. Somebody would have identified that yes, he's there, or something, some fingerprint, something which shows that yes, he was also there in the crime, place of crime. Otherwise, last in theory would be very dangerous to convict people.
Subject to correction, Lordship. Last in theory will come into play when the time gap between the incident and last seen with the victim, if it is so small, then the possibility of any third person, that is ruled out.
No, postmortem report, I think it says only within 24 hours.
Yes. So far as Lordship,
So,
PW3's statement position is concerned, the Kaunguha of the Jeliwa village where the occurrence took place. So he has deposed at the night hour itself. He has received one phone call that an incident took place, a girl was found died. That is a page lordship. Page 14 of the paperwork.
Page 40.
Yes, boss. Deposition of PW3. West Bengal. May I read, lordship? Page 14 of the
1414.
one.
Okay.
I do not know the accused name. I don't know complainant Tuniram Dole. I do not know the victim. One night in the month of March in 2012, as I was sleeping in my house, one person informed me over phone that a girl was lying dead on National Highway near Cherma village. That means the occurrence took place in the night itself. That is remain undisputed. That is not challenged by the defense side. The time gap is very small. Therefore, lordship, the possibility of another person being with a deceased which was alive is very less. There is a judgment also to that effect. Ram Gopal versus State of Madhya Pradesh, 2023. 5 SCC 534.
Yes.
This is not complete submission of the lordship. It is entirely the case is based on the last theory.
Yes. That's all.
That's one more thing I just want to point out. At paragraph 36 of the paper book, deposition of PW 17 lordship, who happens to be the scientific officer lordship,
Age
page 36,
36. Yes.
who happens to be the scientific officer. So, he deposed that on 21/03/2012. She received a person. The last occasion also had a query. So there's regarding the breaking of chain of custody. So perhaps they received on 21/03/2012.
Date of
And
incident.
one more thing, Lordship, date of occurrence is 24/03. You have to do one again. And again, I'd like to come to page 34 also, Lordship. PW 16. Who is, happens to be the senior scientific
This
officer.
LCR.
NCP.
What is the date in the LCR?
Lordship, that's what I just want to see. The date, just want to see.
21, apparently it is a typing mistake.
Yes, perhaps.
What is the date of death?
It is 24th, 20 occasion is 23rd March 2012, and the dead body was found on 24th.
23 March.
Yes, and dead body was found on 24th.
Is it- The original says 27, not 21. It's a typing error. This is case diary also, it is 27.3.
The position was mentioned, that we can.
The deposition is, it is wrongly typed as 27, 21. The original, the case diary reflects 27. Exhibit 8 reflects 27. This is a typing error we'll ignore. And yes, you're right, there is a case called CDR, but it's not exhibited. Yes.
This is my humble submission before.
Subject to correction, Lordship, what I have understood from her submission is that, Lordship, she has stated that PW 5, 6, and 7 undisputedly stated that the victim was seen along with the appellant. And if you, I am not wrong, Lordship, may kindly see that page 18, there was a suggestion that he did not state before police. And police at page 33, it is confirmed through IO that during investigation, it was not stated that victim went along with the accused Deepak Gogoi. It is their investigating officer who stated, admitted in cross-examination, Lordship.
Which page?
Page, Lordship, may kindly see page 19 first. PW 5.
Page 19, yes.
Page 95, cross-examination, first, last 3 lines, Lordship will find, it is not a fact that, first paragraph, last 3 lines, that I did not state to the police that I had seen accused Deepak Gogoi going out with the guard. So he denied that suggestion. And this fact, now, Lordship may kindly turn to page 33. Is PW 15, is the investigating
This
officer.
page 19 is PW.
Vinod Puri.
Now page number.
33. What your Lordship will find, while giving statement before me,
He is PW.
he is PW 15 IO, investigating officer.
Yes.
While giving statement before me, PW Vinod Puli
Where is that?
that he had seen.
Where is,
Rosna-
oh, last line, okay.
Did not state that he had seen Rosna Dole going out with accused Deepak.
Yes.
The next Lordship analysis PW six, page 21, I'm referring. Starts from page 20, I'm referring to page 21. Here, this witness admitted that Shobita Dola, she admitted that while making statement before police, I did not state that accused Deepak had called Resna away while she was watching the function. And probably because this reason also in the FIR, name of Deepak is not there. Because at the initial point of time, it was not alleged that Deepak has taken the gun.
Yes.
Regarding PW7 losses, I've already seen at page 22 that he has not mentioned any time. Because there is a question that victim went and then returned, then again went. So when he saw that part is not there regarding PW7.
Yes.
So I have pointed out, Your Lordship, that judgment, at least I have given one Lordship. Lordship will find that Kanhaiya judgment, it is clearly said that circumstances which prosecution wants to rely, there has to be proved circumstance. Because these are not proved circumstances. And even if we assume that their last injury is there, that itself is not sufficient for conviction in absence of any other material. And just one thing also, I will not take much time on the one side, and I will share to your Lordship, because my learned friend has relied on the cross-examination part. Because of that part only. Vision bench of Gujarat High Court Lordship. Paragraph 14, Lordship may NDC. Paragraph 14 to 17. 18. Paragraph 14 to 18.
Yes.
Paragraph 14. Mr. Nanavati strongly relied on the fifth circumstance, which during the course of cross-examination, questions were put to witness Dharmji and Premji by the lawyer of the accused, which unmistakably indicated that accused number 1 and accused number 2 admitted that a fight did take place between them on one side and Dharamsi and Tulsi on the other during the night of the occurrence. Mr. Nanavati supported his argument by drawing our attention to the cross-examination of the prosecution witness Dharamsi, Bika and Premji on behalf of the accused. In the cross-examination of Dharamsi, it was suggested by the lawyer of the accused that Tulsi and he had severely beaten accused number 1 and 2. and he was falsely implicating the accused in order to save themselves from a case that might be filed against them. A similar suggestion was also made in the cross-examination of Premjit Prat, and the suggestion was as follows. So that basically there was allegation that they assaulted the accused person. Now paragraph 15, Lordship may kindly see. To put it shortly, Mr. Nanavati, in advancing this argument, merely repeated the main ground on which the conviction of the appellants was based by the learned session judge, that the accused number 1 and accused number 2 admitted their presence at the scene of the offense, and that they were beaten by Dharamsi and Talsi. If the lawyer of the accused puts a suggestion to a prosecution witness that a particular event happened in a particular manner, then it cannot be implied that the lawyer commits himself to such an assertion. Suggestions put in cross-examination are no evidence at all. And on the basis of such suggestions, no inference can be drawn against the accused, and that he admits the fact referred to in the suggestion. It is possible that in putting suggestions, the lawyer of the accused, if he thinks fit and proper, may not put the entire case of the accused in the cross-examination of the prosecution witness. Moreover, the lawyer who appears for the accused, keeping in mind the facts of the case that he defended, has the right to take up a defense that he thinks just and proper. In Naga Basain versus Emperor,
But Mr. Ahmed, we'll have to respectfully disagree with this paragraph 18. You see that there are two things. Number one, I give you an example because I was present in court on that day. It's a case of food adulteration, and a sample of curd was taken by the food inspector. Now, the food inspector does not say that how he collected the sample. In a food case, there's a procedure to collect a sample, and he did not utter a word in that. And the defense counsel put him a question that, look, when he picked up the sample, he did not churn it. You see, in curd is a thing where if you keep it in a bottle, the curd will go down and the water will come up. So therefore, if you take up only water, then it will be adulterated. But if you churn it, then you understand the real consistency of a curd. And so the defense put a question that you did not churn it. And he said, no, yeah, I did. And you see, in the cross-examination, the suggestion which came led to his conviction. And there is absolutely no flaw with that. Number one, because of the fact that the prosecution puts the question to a prosecution witness. And if you are a defense counsel, what else will you do? You can ask him questions and you can give him suggestions. See, if suggestions lead to a incriminating evidence, I would disagree that it will not cannot be kept in a higher pedestal. Number one. Second is, you see, this paragraph 18 is in three parts. First part we have said, the suggestion in the cross-examination cannot be used to fill the gaps of the prosecution. Now, this is one part. This second part is, such suggestion cannot stand higher than the statement of the accused under 342 CRPC. 342 is 313. So, that part will come a bit later. Suggestions cannot stand higher than that, because you see, suggestion is only a suggestion. He may say yes or no. But 313 is the incriminating materials which are put to the accused person. So this is okay. But the third part, you see, the statement of the accused under 342 CRPC cannot be used as evidence against the accused unless the prosecution proves the case by him by satisfactory evidence. Now, you see the example of what you call 106. It's a train ticket or bus ticket. What is the example? It's a bus ticket or train ticket? Bus ticket. So, if I am traveling without a ticket in a bus, the burden is on me to prove. So the prosecution will only say that when we saw this person, he did not have this ticket. that itself is an incriminating material against them. And 106, the duty is cast on the person to show that he had a ticket. Correct. So therefore, even this third part, we can't agree that the statement of the accused and the 313 statement, because I put that question to him. I did not have a ticket. And he does not give a reply. 106 burden is on him to show, and therefore that leads to a conviction. So this para 18, we have some reservations, unless you can explain in a better way.
And I am relying only on one aspect, that on the basis of that cross-examination part, also, he cannot be convicted, only on that part.
Well, I've given you an example. This Kurd, I've given an example. You find a flaw in that, in that example. You see, there was nothing. But in a cross-examination and a question is put where it elicits a incriminating answer, why it would not become an evidence?
Yeah.
Take any example for whatever comes to your mind. Think of an example. Let us say pickpocket. Nobody asks him this question that this particular purse is from that person A, and he puts a question that you got from where. He will say from him.
Actually, when lordship that if I lordship get this judgment lordship. Then lordship that last in theory only that part is there, and except that nothing is there. And that the girl was taken for second time, that suggestion is not there in the 313 lordship. The question was not there. And my learned friend has already submitted citations in this regard, he will place lordship.
We've got the answer. You see, you started reading from paragraph 14, correct? The answer is in paragraph 12. Last 4 lines from subpara 5. You've seen para 5. There's a subpara in between. There's a bracket at page 4. 5. That during course of cross-examination, questions were put to Dharmeshi and Premji by the lawyer of the accused, which unmistakably indicated that accused number 1 and accused number 2 admitted that a fight took place between them on one side and Dharmeshi and so and so another. Now, that cannot become an evidence in the cross-examination. That is only what is trying to be explained. That's why we read it, because it apparently High Court would not have given that observation, because it is in the cross you are putting that no, this did not happen. Accused one did have a fight with him and then he left. So that fight becomes an admission of a crime committed. The High Court says no, it can't. That's the principle altogether. But that suggestion is of a lawyer, and it may not be a defense of the accused person. But there is another aspect to it. If you admit, you see, this is not a thumb rule. Supposing you admit, you give a suggestion to the witness that no, this accused person was just standing there with his knife, and this fellow came and fell on him. He was standing there with a knife. This fellow came and fell on him, and therefore he died. Now you see that becomes an admission of the fact that this knife was with the accused person. Then you can't deny it. You can't say that this suggestion would not be equated to a an admission, because it's a specific plea taken. He was standing there with a knife and he fell down. Now under 106, now you'll have to show that this falling was his own and it was not a case of stabbing.
But here also the prosecution witnesses not said that that second time that incident.
That's okay. She has given an explanation. We'll consider that.
That circumstance is not there in 313. That question was not. My lord, already all the factual part has been covered both by my learned friend as well as the PP, my lord. And in my submissions also, my lord, I have enumerated the grounds which I am relying.
Just call someone. Call someone. Yes.
Now, my lord, to a pointed query which has come from your lordship, that apart from last seen theory, what is there in the evidence? The learned additional public prosecutor relied on a judgment of 2023. My lord, that judgment, in fact, in some words, it helps the defense. My lord will kindly take up that judgment at para 10.
Helps you.
This judgment, apart from last seen theory, there were two vital incriminating materials which corroborated with the last seen theory. That is the recovery of the weapon, that is the axe, and the enmity between the victim and the appellant has surfaced in the evidence. My lord will kindly see para number 10.
So far as the facts in the instant case are concerned, it was duly proved that the death of the deceased was homicidical. It was not disputed that the petitioner had taken the deceased with him on the previous day evening, and thereafter he was also seen with the deceased by the witness Vijay Singh. And the very next day, early morning, the dead body of the deceased was found lying in the field at village such and such. The time gap between the period when the deceased was last seen with the accused and the recovery of the corpse of the deceased being quite proximate, the non-explanation of the petitioner with regard to the circumstance under which and when the petitioner has departed the company of the deceased was a very crucial circumstance proved against him. Having regard to the oral evidence of the witness, the enmity between the deceased and the petitioner has also surfaced. The corroborative evidence with regard to recovery of the weapon X alleged to have been used in the commission of crime from the petitioner also substantiated the case of the prosecution. So there were link evidence, my lord. Now, this very judgment at para 6 says, at best, last seen theory can be an additional link to the otherwise chain of circumstance. Para 6. It nowhere says that it can be the sole basis of a conviction, madam. It may be noted that once the theory of last seen together was established by the prosecution, the accused was expected to offer some explanation as to when and under what circumstance he had parted the company of the deceased. It is true that the burden to prove the guilt of the accused is always on the prosecution. However, in view of Section 106 of the Evidence Act, when any fact is within the knowledge of any person, the burden of proving that fact is upon him. Of course, Section 106 is certainly not intended to relieve the prosecution of its duty to prove the guilt of the accused. Nonetheless, it is also equally settled legal position that if the accused does not throw any light upon the fact which are proved to be within his special knowledge in view of Section 106 of the Evidence Act, such failure on the part of the accused may be used against the accused as it may provide an additional link in the chain of circumstances. Now, my lord, in the instant case, my lord, from the very inception, the chain is broken, my lord. There is no, despite there being opportunity of adducing more credible evidence, my lord, the prosecution has not brought all those evidences. So that draws an adverse inference as well against the prosecution, my lord. For example, 53A and non-examination of that person from whom, to whom that bike belongs. That Saikia, Prafulla Saikia. So that is what, my lord, I just said that the only judgment which they relied is this 2023, but 2023 judgment, my lord, it is not solely on the basis of circumstantial evidence. There were link evidences in the nature of enmity, that is, motive was attributed, and the weapon was also recovered.
Now, I suppose you have read this and then you are making a submission.
Yes.
You have read it?
Just now.
Now, you still go ahead with that you find this supportive of you.
Because, my lord, here there were link evidences.
Then I'll tell you. Come to, if you stand by this judgment, then please come to paragraph 3. In para 3, in the middle, the alleged recovery of weapon, this is a submission of senior counsel.
Yes.
Correct. Para 3, in the middle, the alleged recovery of weapon X from the petitioner also could not be a ground for conviction, more particularly when the doctor who had carried out the postmortem of the dead body of deceased had not opined that the injuries found on the dead body of the deceased was possible with the said weapon. Correct. And this judgment, we don't have anything to say that this was a weapon of offense which was proved. This judgment doesn't say so. Maybe the trial court record would have, but High Court judgment may have, but this judgment does not say so. Now come to paragraph that paragraph 8, Satpal is quoted. Here it says, if the accused offers no explanation in the middle last part of the para 6, if the accused offers no explanation or provides a wrong explanation, abscond's motive is established, and there is corroborative evidence available in any form of recovery of otherwise forming a chain of circumstances. Correct. Now, in this paragraph 10, which we are reading, here last 3 lines is the corroborative evidence with regard to recovery of weapon of X alleged to have been used in commission of crime of the petitioner also sustained the case of prosecution. So therefore, you see, mere recovery itself became an evidence so far as Supreme Court is, if we accept this. So recovery of motorcycle itself is a circumstances that some recovery is made. But you see, link with the crime is not there. So either this judgment supports you or does not support you.
My lord, since this judgment was relied by the prosecution, my purpose was to show, my lord, that it is not that only last seen theory, because this judgment categorically says that it may be an additional link in the otherwise chain of evidences. Firstly, and secondly, my lord, that submission of senior counsel Salman to Khurshid appeared probably. So that is what I found in category. Yes. It was his submission because the evidences were not recorded meticulously here, my lord. It was his submission that simply by recovering an X, probably you cannot connect the weapon with the accused. But my lord, in the absence of evidence, but at least, my lord, what we can discern from the judgment is that the weapon of recovery was there. But in the instant case, there is no weapon. Rather, my lord, that 2014 4 SCC 517 Kanhaiya Lal, it my lord categorically says that the circumstance of last seen together does not by itself and necessarily lead to inference that it was the accused who committed the crime. There must be something more establishing connectivity between the accused and the crime. Mere non-explanation on the part of the appellant, in our considered opinion, by itself cannot lead to proof of guilt against the appellant.
Into consideration.
Acceptable.
Close it. Third, Mr. A. Ahmed, counsel for the Ms. A. Ahmed, as well as Mr. M. Biswas, learned counsel for both the appellants, as well as Ms. S.H. Boral and AP for the state. Argument is concluded, judgment is reserved.
Acceptable.
You want us to take your matter first?
For hearing item 2 to 14.
Which is your item?
I think will be 4, 5, 6, 7, and 9. These are all common just from
No, just let him note it down. 4, 5,
6, 7, 9.
4, 5, 6, 7, 9. Just give us 2 minutes. Let this file come. Yes. No, all are bundled up together, so it'll take 2 minutes time to take it out. Cool.
Yeah, Can I go ahead with B? Right. Right. E2 cut at the we have already taken it. Where you? Oh, and me society. Yes.
But the law point.
Mr. Vishwa and Mr. Das, we'll be breaking up at about 2:15. We'll be here till 2:15. Thereafter, we'll have to break. There's a single bench and again there's a full bench. So therefore,
Before I begin, in terms of lordships, law point involved. This is similar in. And that will go to the root of the matter. The lordships agree with me that the electronic evidence which are on record are not admissible.
are not
Admissible in evidence.
Not
They
admissible.
do not have been admitted.
okay.
There are two types of electronic records which are there, on record. One, it was taken on the basis of disclosure memo said to have been made by accused number 20. And the other on the basis of accused number 9. Now, these computers which were there in NIA office, from there, printout of one of the emails were taken out. And other, they could not open. And this email was no printed, but there is no certificate. The certificate does not certify or say anything about the printout. That is email. So that will not go in evidence, that will be my submission. Relying on PK Bashir's case. And the second one is 19. That also from one of the emails, accused number 19 was using 3 emails. Out of 3 mails from one email, they took out, they took the printout. The spotted number 74 was given the certificate, but that was not exhibited. And all these emails were put in a stride list, and sent to Chandigarh CFS. So the emails which were taken out of the instance of accused number 19 were printed in, admittedly, printed in CSS Chandigarh. And 2 scientific officers, PW 5 and 44, they proved those, but there is no certificate at all. So therefore, my submission would be that these are not admissible at all. And if these email goes, there will be hardly anything on it. Now I will begin. Your Lordship is taking up first item number 4. S. Rakesh Singh. This accused number 6 was convicted under 3 provisions of the law. Section 18. Section 18 of UAP Act, even 8 years, RI 8 of 8 years, and fine of rupees 10,000. In default, further imprisonment of 1 year. Then, under section 20, he was awarded a sentence of 7 years RI and a fine of 10,000. In default, 1 year imprisonment. Then under section 121 capital A of the Indian Penal Code, accused number 6 was convicted to undergo 10 years RI and a fine of rupees 10,000. In default, 2 years of further imprisonment. I'll first place before your Lordship the conviction under section 20 of UAP. I'm not going into FIR and actually go exhibited. There will be no requirement. Now, section 20, all the accused persons have been found guilty under section 20. If your Lordship takes up the paper book 1, volume 1, part 1, volume 1, part 1, volume 1.
This small compilation or the
Some are there, some are not,
okay.
but some your Lordship have to. Most of the things are there. Part 1, volume 1.
I'll have to take lessons from Mr. Pallab Bhovik for weightlifting.
Most of the required documents I have given in the compilations, but few actually left out.
She left out.
Right. But evidence, some evidence I'll have to take the lordship. Yes, evidence. But if it spills over, definitely I will make another one and include everything. This is not much. And if your lordship can turn to page 137. Lordship getting up, then after 5 minutes, we can review. They have come.
Oh. Yes, we'll take a break and come.
I come to page 137. At serial number 2, at page 137. Serial number 2, if your lordship will see at page 137, the name of accused number 6 appellant is mentioned. S. Rakesh Singh. And at
Yes.
next page, charge under section 20 has been put against all, including the appellant. Page 139. That you being members of terrorist organization involved in terrorist act, as mentioned in the foregoing head of charge in the 5th head, and thereby committed an offense punishable under section 20 of UNLF Activity Prevention Act 1967 with like. So there are two things here, Your Lordship. Please. You being member of the terrorist organization, the first is that I'm being a member of terrorist organization. The second part is involved in a terrorist act as mentioned in foregoing head of charge in the 5th head. Kindly see the 5th head at page 138. 5th head. That you being a member of United National Liberation Front, terrorist organization, did terrorist act by using grenade, explosive injuries to persons, damage to property, kidnap, attack for ransom, and thereby committed an offense punishable under section 16 of the Unlawful Activity Prevention Act 1967 within my cognizance. They all have been acquitted under this section. 16 all have been acquitted because not a single instance of terrorist act was sent for trial. Not a single instance. So they have been acquitted under section 16. No terrorism. I'll place section 20 of the UAP Act. The relevant UAP Act, your lordship will find in compilation number 2. Lordship can come to page 1 of compilation 2.
This, today, which you're doing, okay.
In the meantime, there has been lot of amendments, and this matter relates to 2010. So I have given a appropriate UAP. So it starts with from field number 1, Unlawful Activity Prevention Act 1967. The relevant section 20, my lords, we get at page 30. 1. Punishment for being member of a terrorist gang or organization. Any person who is a member of a terrorist gang or a terrorist organization which is involved in terrorist act shall be punished with imprisonment for a term which may extend to imprisonment for life or shall also be liable to fine. Well, there are two postulates of this section 20. First is that one should be the member of the terrorist gang or terrorist organization. These both the expressions have been explained. I will take the question. And the second is that such terrorist gang or such terrorist organization is involved in a terrorist act. So when I proceed, I'll show your lordship. This section 20 of UAP Act is in fact verbatim reproduction of section 3, subsection 5 of TADA, which was interpreted by a recent Supreme Court Judge 23, that Arup Bhuiyan, because Arup Bhuiyan, a bench headed by Justice Karju, without even reading section 3.5, said that it provides only punishment for being a member, nothing else. And that mistake continues. Luckily for me, the recent judgment, which was a review judgment of Arup Bhuiyan, it involves only section 10A1 of the UAP Act. If your lordship can just come with me to section 10. Section 10, your lordship will find at page 9. We're concerned with 10A1, Roman 1. My lord got it. Where an association is declared unlawful by a notification issued under section 3, which has become effective under subsection 3 of that section, a person who is and continues to be a member of such association. So this is only punishment for being a member of the unlawful association. Now there is a difference between this and section 20. Section 20 has two postulates. One, you have to be a member of a terrorist gang and a terrorist organization, which is involved in a terrorist act. Now, terrorist organization is defined under section 2M. Your lordship can kindly see 2M. And terrorist gang is defined under L. At page 3. At page 3. Terrorist gang means any association other than terrorist organization, which whether systematic or otherwise, which is concerned with or involved in terrorist act. Now, terrorist gang, nowhere your lordship will find there is a schedule or something where, because it cannot be put in any bracket. Terrorist gang, any 3 persons will form a gang. Any 2 persons can also form a gang and they can commit. Therefore, the second postulate of section 20 becomes essential, that this gang is involved in a terrorist act. That is sine qua non for application of section 20 in such a cases. Now, if I come to terrorist organization, your lordship will see terrorist organization means an organization listed in schedule of an organization operating under the same name as an organization so listed. Now, if your lordship come to, so a terrorist organization is an organization which is listed in the schedule. Your lordship comes to page 26. Is it here? 26. United Liberation Front of Assam, then we are concerned with 4.
Serial number 4.
We are concerned with 4, yes. United Nations Liberation Front, UNLF.
So in fact, second postulate is not required to be proved. One, it is there in this.
This is the problem. Because it comes, I also thought like that. The lordship will kindly come to section 35. Section 35. But whether for terrorist gang it will be required, I'm just asking a question to myself. Because terrorist gang, your lordship will not find anywhere. So whether terrorist gang, unless it is involved in a terrorist act, section 20 will not come in for terrorist gang. Your lordship, let's read it again, section 20, page 30. I'll skip terrorist organization and I'll read only terrorist gang. Any person who is a member of a terrorist gang which is involved in terrorism. Now, terrorist gang has not been anywhere in the schedule, or there is a declaration like unlawful organization association. Unlawful association, there is a declaration. And a list is there that these are unlawful organizations, association. Terrorist organization is given in the schedule, but terrorist gang, your lordship will not find. But for terrorist gang, the Terrorist Act has to be proved. Now, what has fallen from your lordship is that since the terrorist organization is there in the schedule, therefore the second requirement need not be put. That's what has come.
Yes.
Let's go to section 35. Section 35 of UAP Act. How is the schedule?
We only hope that these questions will not bracket us into a terrorist gang.
This is at page 16. Now, these are very, I say that I get richer by getting into conversation, but the conversation should not be like, all right, I don't want to hear, but you continue. I have already decided. That impression I have got once, so I'm happy today I'm not getting that impression. The lordship will kindly come to 35 at page 16.
It's a false facade. What you see is what you don't get.
Yes. 16.
Yes.
Be open-minded, everyone, matter law, it's a law. Everyone makes a mistake. Everyone makes a mistake. And before the former Chief Justice Mehta, I said that I don't know. He says, I also don't know. Nobody can say that he knows law. You read it, read and read. So I'm coming to page 16. The central government may, by order in official gazette, add an organization in the schedule. Add also an organization to the schedule which is identified as terrorist organization in a resolution adopted by the security. We are not concerned with it, Security Council. C is remove an organization from schedule. Now, how an organization will be added in schedule, your lordship will find in subsection 2. Central government shall exercise its power under clause A of subsection 1 in respect of an organization only if it believes that it is involved in a terrorism. Now, this is by an executive fiat. There is no check and balance.
No, but after that it goes to that
No,
tribunal.
that is on that is unlawful association. Section 3 and 4. Come to that. Because that is a distinguishing feature in Anup Bhuya, which was decided in 23. That's a distinguishing feature.
Okay, you're trying to project that once recourse to section 35 is taken and somebody is added as a terrorist organization
Ah.
is merely an executive act and which is not backed by the tribunal decision, and therefore you say that
Yes.
it's still questionable.
Then questionable, because if it is only, suppose it is in the list, and membership, it becomes punishable. Then your lordship will see, section 20, the punishment can go up to life. Lordship has noticed section 13, section 20, which is involved in terrorist act shall be punishable with imprisonment for a term which may extend to imprisonment for life and shall also be liable to fine. Now, membership is an offense under section 38. You kindly come to 38. Offense relating to membership. A terrorist organization. If your lordship see the difference between the headline of both the sections.
But just a question, because this I've read somewhere, this UNLF. UNLF was declared unlawful through by a tribunal.
Yeah, unlawful by the tribunal
Huh.
under section 3. But terrorist organization is different. Terrorist organization will not be unlawful. It is terrorist organization, severe. So your lordship will kindly see 20. 20, just the heading. From here, I'm trying to make a point.
Yes, terrorist organization, terrorist gang.
No, punishment for being a member of terrorist gang or terrorist organization,
Yes.
which is involved in a terrorist act. The kindly see 38. Offense relating to membership of a terrorist organization. Now here, a person who associates himself or professes to be associated with a terrorist organization with intention to further its activity commits an offense relating to membership of terrorist organization. This is a specific provision for being a member of terrorist organization. But this is also not alone. Prosecution will have to prove that he has associated himself or professes or to be associated with a terrorist organization. Here also there are two postulates. Now, kindly see the punishment of section 2.
10 years.
Yes. Not exceeding 10 years. There it is life. So therefore, 20 is not membership alone. I'll further develop my argument. Your lordship has seen the difference. For being member of a terrorist organization, if a person associates that I am a member of a terrorist or professes to be a member, he can go to jail for 10 years maximum. But here 20, if it is also interpreted that this is also an offense for being member, then it is life. So there must be some reasons. According to me, as I have said, the section itself is very clear that it has two postulates. One has to be a member, the prosecution will have to prove that the accused is member of a terrorist organization. And secondly, that such terrorist organization is involved in a terrorist act. Only then he will be given life. Because it's on the scale, of course. But can be given up to life. So there must be some difference between 38 and 20. I will, my lord, place membership where it started. The mistake, my lord, started from 2011. From there only, and I will please. Fortunately, I don't know whether these books actually. They have brought books, but for your lordship, they have not made.
No, it's okay, we have it.
Then your lordship will take it up first. Anup, first your lordship will take up State of Kerala versus Rani. It is 2011, 1 SCC. 1 SCC 784.
Just on SCC key.
Sorry, my lord, this.
Just something, put on internet. Yeah, SCC online.
2011 1.
No, just a moment.
2011 3.
Just a moment. No, it's okay. No, it's not required. It's not required. Just give me the citation again.
2011 1 SCC 784.
2011
1 SCC
1 SCC
784.
784. It's okay. I forgot the password. I opened it here.
Well, I think.
No.
I can-
No. You see, since I use tab, not the desktop, I have forgotten the password. But I have this. Don't worry.
Even my books they have not brought. Very healthy. My books they have not. I
No,
can.
but nowadays you'll have to go to E mode. I don't know. Your brother is pressurizing hard.
I don't know. Now, my lord, here, if you look, oh, sorry.
Paragraph?
My lord, I'll also. My lord, here the date of decision is important because it's all three decisions are by authored by the same judge, Justice Markandeya Kach. Now, this, my lord, is this case is under section 10, 3 and 13. Your lordship got it. Section, this is a case of section 10, section 3 and 13 of UAP Act. Lordship will find. If your lordship will come to paragraph 10. Paragraph 10. Yes. Moreover, even assuming, did your lordship get?
2011.
One SCC, it's a state of.
One SCC 784, State of Kerala was a Ranif. Para 10 is something else is coming up.
At page 788, my lord, maybe I have. 788, if your lordship will say.
Para 10 is as regards the allegation that the respondent belongs to PFI. That is how it starts.
Yeah, it is start, but your lordship will come to page 788, paragraph I have not looked at.
788, middle page.
788, yes.
This is 789.
Here, my lord, I have written, moreover, even assuming that
Yes.
PFI is an illegal organization,
Yes.
in fact, it should have been association. We have to consider whether all members of the organization can be automatically held to be guilty. Lordship, my lord. Now, this was the interpretation of section 10. If my lord will kindly see section 10. Section 10. Section 10 of UAP is in 4 parts. A, section 10A. A person who is or continues to be a member of such association, this is one part. Takes part in the meeting of such association, this is another part. Contributes to or receives or solicits any contribution for the purpose of such association, this is another part, or in any way assists the operation of such association. So it's not just 10, it's 10A, 1, 2, 3, 4. If it is for subsection 1, A, Roman 1, then I could have understood. But here also, this was overruled in 2023, because as your lordship has said, that there is a detailed procedure for declaring an organization as an unlawful association. Detailed procedure is provided. Kindly come to section 3 at page 4 of the compilation. Section 3.
Because I had been a chairman of one of those.
Declaration of an association as unlawful. The central government is of the opinion that any association is or has become an unlawful association. It may, by notification in the official gazette, declare such association to be unlawful. Every such notification shall specify the ground on which it is issued and such other particulars as the central government may consider necessary. Provided that nothing in this subsection shall require the central government to disclose any facts which it considers to be against public interest or disclosure. No such notification shall have effect until the tribunal by an order made under subsection 4 confirms a declaration to be made therein, and the order is published in the official gazette. Proviso is an exception that yes, they can say that before tribunal, they will be considered as unlawful association, and it will depend on the decision of the tribunal that they can do. Proviso and need not go. Then those publication. Now your lordship can come to where any association has been declared unlawful by a notification issued under subsection 1 of section 3. The central government shall, within 30 days from the date of publication of the notification under the said subsection, refer the notification to tribunal for the purpose of adjudication whether or not there is sufficient cause for declaring an association as unlawful. On receipt of a reference under subsection 1, the tribunal shall call upon the association affected by notice in writing to show cause within 30 days from the date of service of such notice why association should not be declared as unlawful. After considering the cause, if shown by association or office bearer or member thereof, the tribunal shall hold an inquiry in the manner specified under section 9, and after calling for such information as it may consider necessary from the central government or from any office bearer of the members of the association, it shall decide whether or not there is sufficient cause for declaring the association to be unlawful and make it expeditiously as possible, in any case within 6 months from the date of issue of the notification under subsection 1 of section 3, such orders as may be fit under either confirming the declaration made in the notification or cancelling it. Then your lordship will see the tribunal. Who will be the tribunal? The central government may by notification in the official gazette constitute as and when necessary a tribunal to be known as unlawful activity tribunal. No person shall be so appointed unless he is judge of a high court. That this speaks its volume. Because there is a set procedure. And then it was said in Ranif case, bringing it, my lord, those American doctrines that guilt by association is violative of 14th Amendment, and here Article 19 and 20. So only guilt by association. And that too, when the virus of 10-1 was not under challenge. It was a bail matter where that was done. Now that has been rectified in the review case of Arup Bhuiya. That has been rectified. And there also, my lord, the argument which was made by the Solicitor General is that declaration of an unlawful association is not by executive dictate. There is a procedure, and it has come from your lordship. There is a detailed procedure. Therefore, if an association is declared as unlawful association, it need not be proved whether it is unlawful or not. It is unlawful. That will go by that. But that case will not apply in case of a terrorist organization. Because here, the only thing available is that if the central government believes that an organization is involved in terrorism, they will include it in the list. Then they will take out also. That is under section 35. So that is only on belief. So it's, in another word, it's on executive dictate. Now, similar, my lord, Ranif case was followed in Arup Bhuiya's case. Arup Bhuiya, I'll just give the citation because similar proposition of law has been laid down. 2011 3 SCC, page 377.
Arup Bhuiya,
Arup Bhuiya.
वो तो खत्म हो गया ना?
23 क्या बोल रहा हूँ, सुन नहीं रहा?
हाँ? देखो.
2011 3 SCC 377. This is date of decision is 3/2/2011. And but there is another decision. All these have been
Three judgments you are referring to.
no 3 judges in review.
No, these are the three judgments you are referring to.
And the fourth, madam, because three judgments have been overruled.
Yes.
And I want to point out where the mistake happened and that continues. So, the third judgment is Indra Das versus State of Assam. This is 2011, 3 SCC, 380.
Please give it again.
2011, 3 SCC, 380. Date of decision is 10/12, 10/2/2011. They're all decided in span of 2 months by the same judge. Now, in Arup Bhuiya's case, section 10 was not involved. In Arup Bhuiya's case, subsection 5 of section 3 was involved. Now, Your Lordship, I have a next tada. Your Lordship will find at page 27 of the compilation. I've given you the compilation.
Yes, sir.
Section 3, my lords, will get at page 29. Punishment for Terrorist Act. Well, it is almost similar, some changes to section 15. I did not take your lordship through that. Your lordship will come to subsection 5. At page 30. Any person who is a member of a terrorist gang or a terrorist organization which is involved in terrorist act shall be punished with imprisonment for a term which shall not be less than 5 years, or which extend to imprisonment of life, so and so. Now, my lord, will kindly compare this with section 20. It's verbatim reproduction. Section 20 of UAP Act and 3(5). If both the sections are juxtaposed and seen, your lordship will not find. The only word missing is shall not be less than 5 years. It's all same. Now see, my lord, how this was interpreted in Arup Bhuiya's case, 2011, 3 SCC. 380. Yes. The lordship has noted earlier, the date of decision is 3/2/2011. Paragraph 8.
Yes.
Please. for the reasons stated above, we are in agreement with the impugned judgment. So far, it takes the view that confessional statement in the question cannot be acted upon as a sole basis for conviction of the appellant. I'm concerned with the next. However, the Tata court has convicted the appellant under section 3(5) of Tata, which makes, my lord, kindly mark, mere membership of a PAN organization criminal. Now, this is where with all respect, my lord, the judge of the Supreme Court has gone wrong. It is not mere. Subsection 5, your lordship has read. He has to be a member of a terrorist organization which is involved in a terrorist act. It is not mere membership. Now, this is also a two-judges bench. Justice Karju and Justice Gyan Sudha Mishra, the two judges. There was a judgment, my lord, in 1997 by two judges. And they interpreted, construed subsection 5 of section 3. I'll please with your lordship. Your lordship, it is there, my lord, by page 75 of the compilation. Page 75.
So there is an inherent presumption that they will not distribute sweets or roses.
No, this is a different case. This is,
No, not that. If it's a terrorist organization or a terrorist gang,
yes,
the presumption is they will not be distributing sweets or roses.
naturally. But that would not mean that, that I'm a member, therefore I'm involved in a terrorist. If I'm a member of a terrorist organization which is involved, then there has to be proof that this is involved. Suppose not in this case, suppose some other cases, some punishment, somewhere something. Because otherwise there is only executive dictate. That executive belief that this is a terrorist organization. So anybody on the ground that you are a member, membership will also have to be proved, but assuming that he is a member, then he can go under section 38, where the punishment is 10 years. Maximum is 10 years on a scale. So why 20? 20 and 38 cannot be an option. That it's up to me to charge you with 38 for an offense of membership of terrorist organization or section 20. There cannot be the option, this option cannot be given to anyone. Now, Kalpanath Rai case, Kalpanath Rai I remember because he was my senior in the university and he became minister. Then he fell off with Narasimha Rao, then Prime Minister. He said in the open court, with Harshad Mehta's case, if you remember, he said in the open this thing that Pradhan Mantri asked for unke samne in the parliament. So he was involved in this case. Your Lordship will kindly come to page 90. I think 89%. 3(5) is quoted. At page, paragraph 33, at page 89. But this is a question of law. It interests me, though I've started otherwise on membership. There is absolutely no evidence. But this, of course, interests me in this question of law.
Paragraph 38,
Paragraph 32 first,
32.
where subsection 5 of section 3 of TADA is quoted. Any
Because,
person-
because in that matter, which I had presided, there was an evidence which came, which is still live in the mind. You see, what had happened was that amongst the terrorist activities listed, one of the act was that arms quota at Zuneboto was looted. And then circumstances came that the ceasefire monitoring committee had given an advertisement in the newspaper to return the arms. And all the arms were returned.
But it was a case of unlawful association.
No, yes, it's true. But the question is that whether this can be a activity which is, you see, somebody gives a clarion call and the arms are returned. Can that, the question arose, because that can be a terrorist act.
Well, unfortunately, doubt, however grave it is, will not form the basis of conviction. Still the presumption of innocence will be there, save and except what is mentioned here. That if some AK-47 rifle is recovered, then presumption will be different. But otherwise, the law will presume an accused to be innocent till the guilt is proven. That is the law. So nothing will depend on if and what it has to be proved, because then your lordship is not, that time your lordship will be, must be dealing with an organization, and this has happened. There was no individual guilt involved in it. It's a case of organization. And if my lord will remember, we have done a lot of cases on presumptions, deeming provisions. 35, there's also that when the central government will believe that it is
Involved in terrorist activities.
that he's involved in terrorism. So it is on the deeming provision. It's below that 35(3). I'll place it later. It's a deeming provision, and your lordship knows deeming provision is reverted. In civil, I'm saying. Here on deeming provision, nobody will be punished. Nobody can send to jail or given life imprisonment. This will be a very interesting question, and then you're lucky that I'm able to place it before lordship. So I'll place 3(5) again. It is quoted in paragraph 32. Any person who is a member of terrorist organization, gang, or a terrorist organization which is involved with a terrorist act shall be punished. So again, and I have read it again, this is akin to section 20 now. So this was the issue and they have quoted. And this has been construed in paragraph 35. The one thing with the date will come in, so I will just clarify. TADA came into force on 23/5/1993. I'll place 35. There are two postulates of subsection 5. First is that the accused should have been a member of a terrorist gang or terrorist organization. After that is date of TADA. Second is that the gang or the organization should have been involved in terrorist act subsequent to so and so. Unless both the postulate exist together, section 3(5) cannot be used against any person. So the interpretation is very, very clear. But there is one thing which I must point out to your lordship. The terrorist organization was not defined at that point of time in TADA. There were no schedule. So this interpretation, according to me, that will not make any much difference, because putting an organization into a schedule is an executive action, not based on any judicial or quasi-judicial adjudication, as done in unlawful association case. So it very clearly says that there are two postulates. Now, therefore, my lord, in Arup, therefore, in Arup Bhuiya's case, when the Lordship of the Supreme Court said that 3(5) of TADA, which makes a mere membership of a ban organization criminal, is not correct. And this is also two judges' bench. Because this Kalpanath Rai case was not placed before this bench, which took the decision. Then, my lord, similar thing is in Indira Das. They are also same thing, and then naturally the same judge authored this judgment also.
बोल दिया और वहाँ केस रिव्यू हो गया बोल दिया
एक बार ruled हो गया कितनी बार can't take a
बोल दिया
But you are still convicted under section 5. Kalpanath Rai,
that have not subsection,
not subsection 5,
not say. I'm concerned with 3(5).
3(5).
3(5) says two postulates. That's very clear.
Is it 2?
Well, at 2 o'clock, I think your lordship is rising at 2:15.
Yes.
And I'm told there is a bail matter. So let me continue tomorrow. I'll also prepare the leftover things in a this thing. And tomorrow your lordship permit me to continue tomorrow.
Assisted by Mr. B. Prasad, counsel for the appellants. Mr. D.K. Das, I'm a senior counsel, assisted by Ms. G.D. Chaudhary, counsel for the respondent, is present. List on tomorrow as a parted matter. For the remaining matters, you are there. Mr. Mishra, your items were item
4, 5, 6, 7, and
4, 5, 6, 7, 9. huh? Nine. So 8 you are there.
2, 3, 8, 10, 11, 12, 13, 14, 14.
Mr. M.G. Singh, counsel for the appellate. huh? That you write, in other cases where he is appearing, you write as criminal appeal 262 of 2016. As hearing is commenced in criminal appeal 262 of 2016. Comma. These matters are adjourned to. Wow. Because that hearing has not started in those matters, so therefore I have to exclude. You're also there?
she also
Hmm? No, just give me the number so that you give it to the court masters who will reflect your names then. Correct. give the numbers in which you are appearing. You will do it at 2 when we sit again. Otherwise, it will be a very chaotic situation to control the court proceedings. Mr. Mishra, can both of you come together in the chambers? There's something I have to ask you.
Item 15 for hearing.
The last 3 days. Now this honorable court directed the registry to inform the appealant commission. Thereafter, we have been engaged in. And that may be noted here also, and the matter will fix for hearing on the next day. Some time may be given to us.
You want some time? This after 2 weeks, as prayed for by learned counsel for the appellant. Ms. Ms. S. Jahalan is present. Okay.
Item 16.
Yes, Mr. Das.
And appearing as an amicus member. Remember the appealant representative also is a lady.
Is a
Is a lady, my lord.
lady.
Lady, and she was convicted for, my lord, careless killing of her minor son. Is it about 1.5 years? 1.5 years. He has been convicted, my lord, under Section 302 and 201 on the.
Because
Indian
it
Penal
appears that the minor child has been battered, thrown in the floor, battered, and then I think there's a injury in the parental area,
Code.
injuries which led to neurogenic shock.
And he was also, my lord, possibly.
He was also burnt,
Yes, from the cold hot water.
hot water.
Yes. Very unfortunate incident. Possibly nothing. Under what circumstances he has committed the that is also another mysterious. And in 313 statement also, my lord, he possibly admitted the entire.
It appeared missed out. Which one?
In 313, my lord.
Chita, I missed it out. Please, which page?
313, lordship will find it with all the statement. 24, my lord, page 20. Page 24, it starts now. Same person as the.
Uh, was this appellant examined by a doctor for a medical condition?
No. From the paper book, I will find it only. Possibly, he was inside one. Understood. Record of the. But act cannot be my lord, same person well.
But I believe this exhibit 7, material exhibit 7 was not sent for forensic examination, that it is,
Was not.
that it is this weapon of assault is not proved.
No. First, it was the extrajudicial confession mail. Then they say that my lord, appealant led to the hiding place mail. And according to IO, at her instance, my lord, this stone was recovered.
But it appears that one of the, I think the husband has said somewhere that in the morning he followed the wife and saw her going towards the tree,
Right.
jackfruit tree, and
Right.
trying to hide something.
Mine. Son went missing in the previous evening only. Thereafter, they said that the entire night they searched but could not find him out. And subsequently, next the morning, he found her activities to be of suspicious nature and accordingly he followed him. And this could be found out that it was buried under the that jackfruit tree. Where garbage were stored.
One producer is like the 98% benefits. Pretty much the whole body, but between that with the university. The motive was not established.
No. Motive was not established.
But then, because this is 313, I did not read earlier.
Right.
313 statement indicates that she admitted boiling of water.
Mine.
And then after that, the child is found burnt with 95% injuries. There's absolutely nothing.
Mine.
No defense
No
at all.
difference at all. And specifically, my lord, no question was also asked whether she would like to, my lord, say anything. My lord, last part of the 313 by. Would you like to say something? I agree myself, I agree with you. He admitted in its entirety, my lord. Question 17.
I think, Nizam, because of this question, question number 17 and the answer, I think we'll have to get the mental condition verified from the jailer.
In the order sheet, I might see whether anything was done at the time of trial. Yes, sir.
At the time of trial. I don't think so.
After she was arrested, she perhaps was medically examined.
But those are routine examination. Those
Those
are not to assess the mental capacity, because with the statement she is giving, that she has killed her son, but she doesn't know why.
Still, it can be done now by seeing the history,
Hmm?
by seeing the history of the patient.
Is
There's nothing on record apart from the extrajudicial confession and the husband's evidence. Now the incident was in the year 17.
17.
Now
Which-
7 years down the line.
because she was orthoed in jail.
Acha. But husband's statement is contradicted, it seems. Because husband's statement is the main one, apart from extrajudicial. Husband, of course, didn't say it to the police. In his cross-examination, I find he had not noticed boiling water, and he was making. I have not seen. Some contradictions are there as far as
Yeah,
husband's
but
statement
she
is concerned.
admits, the victim, the accused admits.
That will be only a link in these circumstances that will be considered. That cannot be the basis of.
No, may not be.
Huh.
But in the last answer, she said that she has killed. That's like pure admission.
Admission along with other evidences will have to be seen. Apart from a 313 admission, other evidences has to be there. The other evidence for what?
Extrajudicial confession.
Extrajudicial is also doubtful, maybe police was there.
No, there was a lot evidence to the extent that she was beaten by the neighboring people. So to what extent extrajudicial confession is voluntary and truthful and devoid of inducement, that possibly lordship will decide,
And few of the witnesses have said police was also there.
Police was also
Now,
there.
whether she made independent confession twice before the villagers once,
That is one part.
Fine.
You're absolutely right.
Fine,
The second part is the recovery of the stone.
fine.
She led to a recovery because not because although it's not been connected, but she led to recovery of one stone.
but she led to recovery. That is not spelled out by the witnesses.
It was in the evidence of IO only.
Only
That-
IO.
that
Witnesses,
She has led. Other
witness
witnesses silent regarding leading, madam.
leading and assembly hearing.
Case 23, madam. IO's evidence, madam. Case 23.
I
madam.
noticed on being led by accused one, recovered and seized a stone by which
The recovery member is not there.
Mine.
Huh.
7 except his evidence, madam. Leading to recovery of stone is silent so far as other witnesses are concerned.
7.
Even in Caesaris, it is written on being shown by the accused mother. So statement.
Because we're refixing this on Monday.
Mine,
I'll like to go through the what you call the evidence and all.
mine.
Because
Because-
apart from admission under 313, if your lordship considers the other evidence as not clinching, then lordship need not go for any medical examination also. But
No,
if your lordship-
there's another aspect. That's what we were discussing. In fact, you see, the present mental condition is not indicative of what was the mental condition at the time of commission of crime.
Yeah.
Therefore, we have our own doubts whether
What about history? If the doctor can show the history of her mental condition.
no, you see, post traumatic what do you call behavior may be different.
What we are concerned with legal insanity. Her conduct before, during and after.
At the
incident.
time of occurrence.
At the time of
during-
occurrence. Huh.
Before, during and after.
Because you
So
see,
here-
it's quite possible that today I have lost someone very dear, and tomorrow my behavior will change. So it's not the commission of crime, but it's the what you call uh, the effect of the loss.
Yes, they must be in a different state of mind now.
People have
1.5 year old child.
difficult times in business. They do commit suicide.
Otherwise,
People-
other circumstances will be what? He saw her boiling water, but then that is contradicted, it seems, although it was not proved as per law, because police did not say. So she was boiling water. After that, the boy was missing. Then morning they searched, they did not get. Morning, he saw her doing something near the garbage. Then he went there and found the body. There was an extrajudicial confession. Then,
You know, for the first part,
uh,
you see this. Come to page 9.
but,
In the cross-examination by defense,
Hmm.
PW1 says that it is not a fact that I have not stated
They are
before
not
the police.
yes, this is what I'm saying, contradiction. But then it was not proved as per law because police did not say. Lordship will see the police's statement.
No, that's okay. But
Ah.
you see, a witness comes and says, I said this before the police.
Ah.
But the police has not recorded it. Now, this is something which I can prove that my statement was not correctly recorded because the police does not show me that what is written. I don't sign it. Therefore, it's not a statement we don't know. And we all know about the experience in police writing the what you call statement of the victim
State.
or witnesses. We all have our own experiences.
But this is not proved according to law because he said it is not a fact that I have not stated. Had he said that it is a fact that I have not stated, then the contradiction ends.
No, no,
But
no, no,
here,
no.
it has to
Because
prove.
no. You see, the art of cross-examination is that you put a question that the question would be by the defense would be that you did not make that statement before the police.
This, yes.
And the court will write. If the answer is I said, they will write. It is not a fact that I did not say. So it is too negative.
Too
That is how we write.
That means answer is positive. Yes, it is not a statement that he had not stated. Then the police, that has to be again questioned to the police. Police has to say, no, he had stated. That part is not true. V.K. Mishra's case, it is explained how contradiction. V.K. Mishra's case, that case, it is said how contradiction has to be proved. But Lordship will go to page 23. Police's cross-examination, he did not say anything.
No.
Contradiction.
You see, in cross-examination, he will not say that.
And he's admitting.
Because you see,
Ah.
one witness says that you don't cross-examine it is the defense who will cross-examine the IO. So therefore, this fact will be elicited by the defense.
Defense, yes.
The witness doesn't have to volunteer the answer. You see, if I am the judicial magistrate, I will not permit the what you call the IO to say something which is there in the case diary. Because I will permit him only to say those facts which have been proved as a part of evidence. Case diary is not a part of evidence. So what is written in the case diary is normally not said by the IO in the courtroom.
What I know is the contents of the case diary definitely aid the trial. During trial, the
No.
magistrate can see.
That's not the way the court is taken. You see, the witness will be asked. The PP will start asking the IO, yes, what do you have to say about the case? So he gives his own description. And then if the APP is alert, PP or AP is alert, then he will ask some questions where the track is taken by the IO. That's one part. Number two, how he is investigated is normally not a statement made by the IO in the case diary. That this is how I went. Because then somebody will ask him that, okay, at 1 o'clock, I'm referring to my case diary at 1 o'clock at 1 p.m. I got a phone call. At 1:10 p.m. I left Thana. At 1:20 I reached the place of occurrence. This is not how the evidence of IO is recorded. So therefore,
There is possibly not evidence.
Not evidence, but then this is not evidence. Case diary is no longer not an evidence at all, but then the contradiction which is required under 161 to be proved, that has to be proved according to the law.
that has to be asked by the defense
Asked by the defense.
to bring
During
the contradiction.
cross-examination, that will come.
But
I
it was
mean,
not.
just let us think over this matter, whether what to be done. We'll go through it. We'll see on Monday, Mr.
Fine.
Hans.
Fine.
Because prima facie, if the admission is of this sort, we doubt whether she is in a good mental capacity. That's the first question. Legal insanity, we don't know. But Mr. N.G. Das, Leonard, N.J. Das, Leonard, amicus curiae, as well as Mr. S. Jahan, Leonard, APP for the state. The positive time the matter could not be heard today. List on, give it Monday.
It's a strange state of affairs.
Strange.
Very strange.
Seriously.
Pardon me?
Strange state of affairs in this case, my
And she answered
mother
that,
killing her 1.5 years son. Very
and when
strange.
her husband asked her, she said that I'm boiling water in order to take
That's why
the
we don't
shower.
know. That is what is, what do you call, stopping us from
I know.
reserving the judgment.
My-
That is something we'll have to
my-
see, because this is an unnatural conduct.
my-
And she
What-
answered that she was boiling water in order to take shower, both herself and her baby. So she was very normal, it seems. She was boiling water. Maybe boiling water fell on the boy and then
No, but then she would not, what do you call,
She could have said it accidentally happened.
because,
With 13
no,
days.
she
we
would
don't
have
know.
run for help. Rather
We don't, she
than-
could have asked for help. She
rather
could have,
than striking
but
him
seeing
with a
the,
stone.
seeing the baby cry, to stone her to death, him to death. Something very unnatural.
Because there are injuries on the scalp. Cut injuries.
So she probably threw the
My-
baby, that's. Child is 1.5. We'll see.
Problem.
Item 17, Mr. Nilanjan Deka is not well. Item 17.
It's not doing well, they. Any other day?
The remaining matters you said at least after 2 weeks. Due to positive time, that could not be taken up. Right? Okay then.